Hey guys, happy Sunday. This is going to be a real quick recording. I want to cook some dinner, but I just noticed that Adriane Love has actually responded to two more of Brian Steele's motions in limine, number 64 and number 65. We looked at the response to 66 on Saturday morning. I'll link that in the description. But here, since this is only for 64, it's a one-page response. For context, I think let's just speed read through what Brian Steele was asking for with motion in limine number 64. So really, they want to preclude any expert testimony which goes to the state of mind or intent of Mr. Williams concerning any element of the above styled referenced charges. So, in a criminal case, an expert must not state his or her opinion about whether the criminally accused did or did not have a mental state or condition that constitutes an element of the crime charged, or the defense of those matters are solely for the trier of fact. OCGA 24-7-704B bars any expert witness from giving an opinion about Mr. Williams' mental state/intent concerning any element of the crimes charged. Deciding whether Mr. Williams acted with a culpable mental state is solely the job of the jury, no matter how clear of proof or incontrovertible the inference. The question of whether Mr. Williams possessed a culpable mens rea must always be decided solely by the jury. The prosecution bears the burden of proving Mr. Williams' mens rea, and they cannot have any witness, expert or otherwise, testify to the jury that Mr. Williams meets a material element of the crime. Now, what are they asking for? Brian Steele Williams wants a hearing on this motion, and at the conclusion of the same, wants this to be precluded. Why were they filing this? Because based upon information and belief, the prosecution is going to recall over Mr. Williams' objection for cumulative additional experts at trial who will again impermissibly read Mr. Williams' mind and state that he is part of a criminal street gang and sang lyrics to further criminal street gang activity. So that's why he filed this as a motion in limine in advance to preclude what he expects is coming from the state. Now, the one-page response here from the state of Georgia by and through Fonnie T. Willis, District Attorney for the Atlanta Judicial Circuit, hereby files his response to Defendant Williams' 64th motion in limine and asks for the court to deny, in caps, defendant's motion. In support, the state shows this honorable court as follows. The honorable predecessor court to this honorable court has on multiple occasions and in written orders overruled the objections defendant Williams now repackages and presents as motions in limine. So they cite these orders here, and that was November 27th, 2023. The court has granted the state's motion in limine to introduce evidence of defendant's words in lyric form at trial and has qualified gang experts, the witness through whom the state will introduce that evidence. The witnesses. The state relies on its previous filings in support of the admissibility of the gang expert testimony and defendant gang lyrics at trial and respectfully moves this court deny defendant's 64th motion in limine. So, I don't know, and maybe I'll jump and take a look at this, but this didn't really address the issue of testimony going to mens rea, culpability, mental state. So we got a one-pager, but maybe that was part of this here. We'll have to look. Now, if we go over to motion in limine number 65, the state's response is a little bit longer, got a little bit more going there. And for Jeffrey Williams, essentially what he was looking for, qualification of expert testimony about jargon or code that is used by the certain accused if proper foundation is laid, right? So that can be permitted. But what's the concern here for Jeffrey Williams, Brian Steele? However, the officer's expert's testimony must not go beyond the plain meaning of the recorded communication. The officer/expert's testimony is inadmissible where it pertains to ordinary language, and the jurors can make a common sense determination of the evidence without the technical aid of the expert. So, if it's common sense, we don't need the expert, and the expert shouldn't be saying it because when it comes from an expert, it seems determinative. It seems like it means what they concluded it meant. There's more weight behind it because you're calling this person an expert witness. But if it's really just something that a common sense person can use common sense to interpret, then you should let the trier fact, the jury, make that interpretation themselves instead of being told what something must necessarily mean. So, and we've read these separately. I will link to these in the description. But what did the state respond? Because they plan to put Detective Viverito up on the stand next. And here's why they argue that, we should be able to keep doing with these expert witnesses, these gang expert witnesses who are officers/gang experts, do what they've been doing. Here's why. The state of Georgia, by and through Fani T. Willis, District Attorney for the Atlanta Judicial Circuit, hereby files this response to Defendant Jeffrey Williams' most recent motion in limine, number 65 of Williams' motions in limine, and moves this honorable court to deny defendant's motion. In support, the state shows this honorable court as follows. 1. Investigator Marissa Viverito was qualified by this honorable court's predecessor as a gang expert after multiple hours of Daubert testimony on December 27, 2022 and October 30th, 2023. In an order filed on January 18, 2024, the court made a finding that Investigator Viverito's testimony is the product of reliable facts and methods, particularly through her ability to identify and describe gang membership and communication indicators. So this is emphasized because this pertains, in the state's argument, directly to what Brian Steele wants to preclude. Conclusory expert testimony about the interpretation of jargon that could be interpreted by someone using common sense. Now, after the court has overruled defendant's objection to allowing Investigator Viverito's expert testimony at trial and qualified Investigator Viverito as an expert, defendant again objects to Investigator Viverito's testimony on the basis that such testimony is improper. Investigator Viverito has been properly qualified to testify as a gang expert and should be permitted to testify as an expert. Investigator Viverito's knowledge, training, and experience allows her to provide the jury relevant and material information about gang communications, identifiers, language, words, and symbols, all of which may appear to have one meaning to a non-gang affiliated layperson, but may have an entirely different meaning in the context of gang activity. And then they cite here Blash v. State, explaining the probative value of gang experts' testimony by stating, Agent Howard explained the meaning of various words and phrases in appellant's jail call recordings, such as the math, flipped, and reach out to, which helped the state show that appellant was unhappy with the prospective witnesses and wanted to talk to them before trial. Agent Howard's testimony was highly probative because it helped the jury understand the unfamiliar terminology in the calls, and, properly understood, appellant's statements using that vernacular showed that he wanted to speak with others because they were cooperating with the state in a manner that was unfavorable to him. Okay, I kind of see that flipped is related, but I still think that's common sense. The math, flipped, and reach out to? Does that really need a gang expert? Like, I feel like this is kind of crazy that the appeals court needs to say that this is vernacular that needs to be... Okay, that's kind of crazy. The letter was largely incomprehensible to someone unfamiliar with the vernacular of Richardson's gang, and the expert testimony was relevant and had significant probative value because it showed that the letter instructed a person who knew about the crimes to keep quiet about the victim's murder. And it was important to show that the letter was designed to keep that person quiet because Richardson's attempt to conceal his involvement in the crimes was evidence of his guilt. Lots of cleaning up in here. Defendant cites no change in circumstance that warrants revisiting an issue that has been thoroughly litigated by both parties and decided by the court as it relates to the anticipated expert testimony of Investigator Viverito. Accordingly, this honorable court should find that further argument on defendant's motion would not be a judicious use of the court's already overextended and most valuable resource, time. Okay, that's kind of funny coming from the state. And the court should deny defendant Williams' motion in limine number 66 without further argument. But this is number 65. But okay. That's why I thought it was weird they said they were responding to the most recent one at the top, but then said 65. When I saw the response for 66 the other day, earlier in the day, 8 in the morning on Friday. So, it was submitted 8 in the morning on Friday, and these came in through the evening hours. So, whatever. I appreciate wanting not to waste time either, but it's just funny coming from the state. Um, yeah, so there's that. I will link to those in the description. Um, and other than that, I mean, court starts at 8:30 in the morning, presumably to talk about some of these things. And that reconsideration, the motion for reconsideration of Dennis, which kind of is mooted because they called Underwood to the stand, but it seems like Whitaker wants to keep the record clean and get some response arguments in writing. We'll look at those as well. And it looks like we're going to have a lot more testimony from Underwood, and we got to rewatch all that Magic City stuff. So I'm going to close this out. Sorry it was so, like, whatever. Just about to go cook my Sunday dinner. So you guys all have a good one, and